All right, good afternoon. My name is Theodore or Tuvia Sandler. Welcome back to the Sandler Law podcast. I'm the managing partner of Sandler Law in Miami, a firm specializing in commercial litigation, commercial collections, and collections in general. Today I'm joined by Richard Payne. He's the president of the Commercial Law League of America, and he's here to talk a little about collections in Canada. Welcome, Richard.
Thank you, Tuvia. We discussed that I'd introduce myself, so I will. As you said, my name is Richard Payne. I'm a lawyer in Toronto, Canada. I have my own practice as Payne Law in Toronto, and I am currently the president of Commercial Law League of America.
All right, and thank you for taking the time today. So, just to jump right in, tell us a little about yourself, your background, how you ended up in collections.
Well, I guess like a lot of people, I didn't go to law school anticipating I'd be doing collections law. I didn't really have much background in the law other than what you see in the media, what you watch on TV. And but the one thing I did enjoy in undergraduate was debating, and I thought that I would like to get into some field of the law that involved litigation or advocacy. When I finished my articles, I'm here in Canada, we have to article before you get called to the bar. Um, I was looking for an opportunity where I'd be able to practice litigation, and I initially got involved with a family law firm because I assumed, rightly enough, that I'd be in court a lot. I hadn't anticipated quite how um, litigious and incredibly conflicted the files would be. And after a few months, I thought, this is not for me. I got to find something else. And that's when the door opened into the commercial litigation and collections world.
Hmm. So you find collections to be less litigious than family.
Oh, absolutely,
Okay.
yes. And I find, the kind of work we do basically comes down to dollars and cents. Is it owed or is it not owed? And it is a rare file that strays into the personal acrimony that seemed to be the hallmark of all family law that I was involved in.
Yeah, and I've definitely heard that about family law. The cases I've seen just kind of touch on it. They can be quite nasty. All right, so down here in the U.S., the collection attorneys and kind of debt collectors certainly have a bad rap. I don't know how it is in Canada, but what's kind of your what's the public perception up in Canada, and how do you address it?
I think the notion of collections litigation is more established in the States than it is here. My impression is that there are very few firms here that specialize in doing collections as a focus of their practice. I think it's usually sort of an adjunct to a general litigation practice. And as I'm sure you yourself find, oftentimes uh, whether you characterize a file as commercial litigation or collections, where does one become the other? But I don't think there's quite the same degree of concern about lawyers who do collections up here as I've heard reflected from the CLA membership in the States.
Okay, well that's interesting. So up in Canada, in the U.S. we have FDCPA, the Fair Debt Collection Practices Act, and then there are also state laws in place that tend to be very restrictive, particularly when it comes to consumer debts. Is there a corollary in Canada?
No.
Okay.
Uh, Here, collection agencies are regulated provincially. We don't have an overarching federal statute like you have down there, and the regulation of collection agencies, as I say, it's done provincially, so it varies from province to province. And in most provinces, they are mostly complaint-driven agencies. So they respond and react when they get complaints from people who've had dealings with collection agencies, and they deal with those um, when there is something that's being brought to their attention. My impression, again, from my colleagues in CLA, is that in the States, there's a much more investigative capacity where the various agencies will proactively and try and determine whether there's any kind of breaches of any of the various regulations.
Right. So, so in Canada, it's purely regulatory. Like, you can't get sued for breach of, the provincial statute. I guess it is.
Well, I mean, I suppose you get sued for anything, but the other thing is that in the states, I know there's always um, a very great issue as to whether or not some of these regulations do or do not apply to law firms as opposed to collection agencies.
Right.
And and here the regulations with respect to collection agencies are for that. For most of the regulations, they don't apply to law firms.
Okay. Interesting. So,
I mean, that being said, we still have our professional organizations that we have to, comply with the regulatory framework that they have. But that's not nothing specific to collections work. That's just general professional codes of ethics that we all have to adhere to.
you mean just like bar, like ethics, like we would have down here in the
Yes,
U.S.? Yeah. Okay.
yes,
Okay. I mean, it sounds much more liberal than what we have down here, at least for creditors.
right.
um, so, and how about the substantive tools themselves? So, if you have a collection, let's say it goes to judgment down here. When I say down here, I just mean the states. um, so you can do garnishment, go after assets, hard assets, etc. Is it the equivalent in Canada? What kind of execution tools are available?
It's much the same here. Yeah, when we get a judgment against a defendant, we typically recommend that creditors get what's called a writ of seizure and sale, because a lot of people don't appreciate that up here, judgment itself is not public notice of itself. You need to take this extra step and issue a writ that then gets filed with the sheriff's office and the land titles office. So that's sort of a passive execution. It just sits there. Nothing actually gets seized and sold, but it
Mm.
sits there as an encumbrance against the individual's name. Um, we also do have garnishment proceedings, which is something we usually use with respect to bank accounts. Sometimes with respect to, if it's an individual, with respect to wages. Um, and then depending on circumstances, if the debtor owns real estate, we can then direct the sheriff to seize and sell that real estate by auction. So that's another option here. If the creditor doesn't have any information about the debtor's assets, we can also make arrangements for a judgment debtor exam or an examination and aid of execution.
Mm-hmm. And would there be contempt proceedings if they don't show up? That's the consequence down here.
Yes, yeah, there can be. The reality is that creditors are always conscious of cost, and they don't want to spend an inordinate amount of money chasing old debt. So often, if they set up an examination and they fail to show, they're already incurring costs for process servers and examiners costs and things like that. And the idea of then bringing on motions to try and seek further relief against the debtor is not something that they're always prepared to finance.
Right. So, so like a writ of bodily attachment, that is a pretty hefty cost, at least here in Florida. It's a few $100s to the sheriffs. It's the same up there. You have to pay the sheriff for every step,
Yeah,
basically.
the sheriffs do not do anything
Okay.
without being directed and paid. And I just filed a writ before lunch. I think the total cost to issue it and file was something just short of $250.
Okay. Okay. Yeah. So, it sounds actually remarkably similar to the U.S. I guess that's good in a way, but all right. So,
Or at least familiar.
yeah, exactly. So, do you ever are all of your clients Canadian, or do you have any cross-border clients with the U.S. and how does that work?
Um, well, through my time being involved with Commercial Law League, I have a lot of colleagues and contacts in the States, and I act for a lot of collection agencies based in the States, collection law firms based in the States, some overseas as well as obviously Canadian clients. But yeah, I do a lot of work for clients that are outside of Canada.
Mhm. And does that affect how you proceed, or is it as long as as I guess the debtor is in Canada, it just proceeds under Canadian law?
Yes, I mean there's the issue that comes up frequently as to whether or not there's been a choice of law or choice of jurisdiction clause in
Mhm.
the supply agreement between the creditor and the debtor.
Right. Okay. And how about you can? It's a pretty easy process to domesticate a judgment from the U.S. and Canada.
Um, I wouldn't say it's easy. Like it's not just a matter of filling out a form and putting it across the court office's website. You do need to commence a proceeding here in Canada
Mhm.
to enforce the, I'll say, foreign judgment, because that's the sort of wording they use it. So a judgment from outside of Ontario, you need to apply to the court to have that recognized as a local judgment. You usually then have to give notice to the debtor to give
Right.
them an opportunity to respond. And you need to file affidavit material from the jurisdiction where the judgment was obtained, explaining that it's a final judgment, it hasn't been appealed, the time for appeal has expired, um, and various other things to confirm that it was properly served, they had an opportunity to respond, and that sort of thing. And then if you go through all of that, um, generally you can satisfy the court that it's appropriate that they grant an order domesticating the judgment. And then once that's done, you can take the usual steps to try and enforce it here.
Okay. Yeah, very similar process here as well. Between states in the U.S., it's a little easier, but a foreign judgment also, it's more or less what you've described. So, I mean, bottom line, you don't need to start a new lawsuit. You can run with your judgment, so to speak. So,
Correct.
yeah. All right. So, what about your fee structure? Collections, at least in the states, typically is a contingency with the client paying costs. More or less. That's the typical. In Canada, is there anything different or any restrictions on contingency arrangements?
Well, when I first got involved with the Commercial Law League, there was essentially a blanket prohibition here in Ontario against doing work on contingency. And I think the main concern for that was with respect to personal injury files.
Mhm.
Uh, but as with any kind of blanket prohibition, it covered everything, including us. That has changed quite a bit over the years, so that contingency fees are known here. But I would say that they are not as generally accepted here as they are in the States. And again, although I obviously, I remember the league and do league work, when I try to enforce an Ontario judgment in another Canadian province, it is often very difficult to find anybody first who is even aware of the idea of doing this kind of work by contingency, and secondly, and perhaps more importantly, to find somebody who's prepared to do that
Uh-huh.
contingencies. You may have found yourself, when you do try to enforce these files anywhere else in the world other than the States, the idea of doing it all on contingency is something that people aren't always prepared to do.
Mhm. So off the bat, usually lawyers up there are asking for an hourly rate.
Um, some will do that for sure, but usually what you'll get is something where they'll take a percentage and also get some sort of suit fee, which I understand in the States is very very rare, but in Canada it's pretty common.
Wow. Okay. Interesting. Yeah. I mean, yeah, down here, I mean, kind of the run of the mill collection, unless it's some gigantic claim, is almost always contingency. So, yeah. All right. Interesting. Um, in Canada, I'm sure there's some sort of corollary to bankruptcy proceedings in the U.S. I
Yeah,
don't know. Yeah. Are they called the
yeah,
same thing or?
yeah. It's bankruptcy. bankruptcy. Yeah, yeah.
Okay. So, and it's has similar stays and protections of the debtor.
Yeah, there's I'm not an expert on bankruptcy either here or there, but yeah, there's basically if a debtor goes bankrupt, it acts as a stay of all legal proceedings. You can't continue unless you get leave of the court, which would be in the ordinary bankruptcy an unusual thing that they'd allow you to continue while everybody else is stayed. Um, yeah, it's a similar situation to what you have down there. We also have sort of corporate reorganizations up here. They call them CCAA. It's an old piece of legislation. I think it dates back to the 1930s or something. But companies use that when they're trying to do a reorganization and avoid a bankruptcy.
Hmm. So, if you have a file that the debtor files for bankruptcy, do you kind of bow out at that point, or will you get involved in a bankruptcy?
I was considering that. To be honest, most of the time, when a notice of bankruptcy comes in, I flip it along to the client and say, "We've got this notice of bankruptcy. What do you want to do? We can file a proof of claim. We can participate. We can do whatever we want." Most of the time, the instructing creditor come back and said, it either says they'll file a proof of claim themselves, or we can file a proof of claim and then just basically close the file and leave it on hold. I can't recall the last time I had a file where the creditor wanted to continue proceeding, even in light of the bankruptcy.
Hmm. Okay. Yeah. I mean, I think most collection firms down here, it's more or less the same. It's kind of a personal interest of mine. I did a lot of bankruptcy before I got into general commercial litigation. I think, it depends on the case. But like you said, if it's a typical bankruptcy, it is very difficult to get involved and turn a profit or, a real recovery on the claim.
Yeah, unless there's some kind of fraud or
Mm.
something, and you've got specific knowledge of that, and you've got a creditor or you are prepared to finance this, like it becomes a um, quite a challenge, and probably not financially worthwhile to do that.
Right. Yeah. No, it's, if nothing else, it's a ton of work
Yeah,
to
yeah,
get into a bankruptcy and try to challenge it. Yeah.
yeah.
So, and just from our conversation, it sounds like in Canada, there's much less of a distinction between a commercial debt versus a consumer debt. So, would you handle them both kind of equally, or do you look at them differently?
Yeah, I will do both, and we don't have that onerous regulatory framework that you have for individual debt or consumer debt. I don't really go out looking for that kind of work, but if clients who send me commercial work have something that and I know this is a live discussion about whether something's consumer or not, because sometimes the defendant may be John Smith, but John Smith ran a plumbing business as a sole proprietor. So, is that commercial or is that consumer? That kind of stuff. So, um, you know, I, I will do that kind of work, and I do get a bit of work from overseas from various hospitals that Canadians traveling abroad run up large debts and stuff, and those are usually insured claims, and it's usually a matter of trying to negotiate between the debtor, former patient, and their insurance carrier to ensure that the account to the hospital ends up getting paid. So,
Mm.
um, yeah, I'm
But
not sure
right.
if that answered your question or not.
Yeah, no, I did. I mean, right. I mean, down here, there's much more of a kind of a red line between consumer commercial
Yeah,
because of the FDCPA.
yeah.
Um,
I mean, the other thing I understand is that in the States, the lawyers who do a lot of consumer debt, and I've met some of those at CLA events before, they seem to be in an office with, two or three lawyers and like 80 staff. Like it's a whole different kind of operation from, what anything I know as a law firm, and they they have a huge amount of non professional staff to manage the massive workload that they get.
right, right. A lot of it if you're kind of a thoroughbred consumer debt collection agency or firm, it's a lot of non-litigation, which is yeah, it's handled through staff, not necessarily attorneys. Yeah. All right. So let's talk about the CLLA. How did you get involved, and how did you rise to the presidency?
Well, I I can tell you that the way I got involved was from some unnamed colleague of yours down in Florida. I Years ago I was doing some work for a local client here in Toronto, and they had an outstanding amount owed to them by somebody down in Florida. And back at the time, I thought, find a lawyer in Florida. And I think it was the Yellow Pages on the you know, on the internet, and I found some lawyer, and his name is lost in the mists of time. Anyway, he ended up collecting the account, and we were talking subsequently on the phone, and he said, do you do a lot of this kind of work? And I go, yeah, I do this all the time. He goes, well, you should join the Commercial Law League. And I went, what is that? So anyway, I looked it up, and I joined, and like a lot of people, I simply sent in my registration fee and started getting the magazine in and stuff like that. And then I, sort of sat back and was waiting for all this lucrative work to start, arriving, and it didn't happen. And after a couple of years of this, I was thinking, well, I'm just, pouring money down a hole. This makes no sense. And I was literally just about to quit, and I thought, well, they're always advertising these meetings. Maybe I should go to one of them. And so that's what I did. I went to New York to the Eastern Region meeting, and it was quite an overwhelming experience for me because I got there, and there may have been one or two other Canadians there, but it's mostly Americans. I think there were a few British people and stuff. But it was quite a shocking entry into this world because everybody else appeared to know all about this and seemed to have been doing this all their lives. And I didn't know a law list from a triadic method. There's all these things that people just assume and you don't. So it was quite an entry. But anyway, I stuck with it, and gradually work started to come, and I started going to more meetings, and as it happens, people start to tap on you to get involved in committees, and then you end up being the chair of various committees, and next thing you know, you're on the board, and here I am. So at this stage in my career and my time with the league, I think I've had lots of opportunities that have come my way because of my membership in the league, and I feel very grateful to the league. I'm very grateful to the colleagues and friends that I've made in the league, and it seemed like the right time to offer up my expertise, such as it is, to take this role for a year. It's actually sort of a 3-year term because you serve a year as president-elect, then a year as president, then a year as immediate past president. So in my role this year, I've certainly been leaning upon my predecessor and my successor, and I think that helps to contribute to some amount of continuity in the direction the league's going in, which is I think a bit of an issue when you only have a 1-year term.
Right, yeah. No, it's interesting. The CLLA, particularly the people who've been in it for a while and have really gotten involved, they all, their faces kind of light up when they talk about it. I think it
Yeah.
really, I think it really is beneficial for the members. I've only been involved for a few months. I'm trying to get involved more, but it's already paid off a little bit for referrals, and I'm enjoying it. So, doing a great
Good.
job as a
Yeah.
president. All right, so why don't you tell us your greatest success in collections and your greatest disappointment?
Um, well, I guess I was thinking about this, and as far as greatest success, like I think any files in which you succeed in getting a good payout for your client, they're all pretty gratifying. And for greatest failures, the ones that I mean, many is the file that you get and you just can't collect, and that's just part of life. But the ones that I've personally have found frustrating over the years is when you go through the whole exercise and you end up suing, getting a judgment, uh, and executing on the judgment. You know there's a bank account there, and you think you're going to be golden,
Right.
and all of a sudden there is like a preferred creditor who comes out of the blue, and while you think you're about to get paid in full, something like our tax authority or the workers' compensation scheme or something like that, every nickel that's been seized goes to them, and that is a source of great frustration to clients and to myself when that kind of thing happens. Because uh, unfortunately, with a lot of these, they're not even. There's no way of knowing they're out there
Right.
until you actually seize money, and then it just all disappears. So that's been a frustrating thing. I in thinking about your two questions on this point, one of the other stories I thought that might be appropriate at this time is one in which I had been acting for a local radio station who had sued one of their advertisers, and these people had run some sort of a hobby farm where people would bring their kids and ride ponies and things of that sort. And anyway, they'd been advertising on the radio for some time. We run up a bit of an account, and so we sued. We got judgment, and we were attempting to execute on this. And I was off. I think I was, in court somewhere. And I started getting these panicked phone calls from my client, and they had been contacted by the judgment debtor, who had said that they were aware of this and they knew we were trying to collect, and they were going to come to the where the station was located at a busy intersection in Toronto, and they were going to come there at rush hour with a truck full of livestock, which they were going to deliver in full payment of the account.
To satisfy the debt. Okay.
Oh, I know. It's like, right out of a TV show or something. Anyway, there were many panicked phone calls back and forth that day, but ultimately we came to a settlement that didn't involve any livestock, and everybody was happy. But I always remember that tale with some joy. So I thought I would,
All right, so it's settled in currency.
yeah. Yeah.
Okay. All right. Good stuff. Richard, thank you for your time. If anyone wants to check out your firm, where can they see you?
So they can have a look at www.rpainlaw.com.
Okay, great. And to check out my firm, it's sandlerlawpa.com. I'm also on YouTube at Sandler_law. Thank you for listening. If you liked the episode, please like and subscribe. Thank you.
Thank you, Tuvia. Thank you for your time.
Thank you.